Hey, this is Tim Blankenship with divorce661.com. Today we're talking about mistakes to avoid when going through the divorce process in California. Let me just switch our screens here. Okay, hey everybody. My name is Tim Blankenship, divorce661.com, specializing in California divorce. And in California, amicable California divorce cases. I'm a legal document assistant that's been doing this since 2012. We're going to be talking about today kind of all the things that I've come across during the week that people have called and had issues with their divorce, called us for help, called us to take over their divorce case for them, and just talk about some of these issues to hopefully help you not have these same problems. I have a bunch of things to talk about. Again, these topics that have gone over. We're also going to be answering your questions. So if you're watching this live, feel free to ask your questions in the chat. I'll be taking a look, watching the comments. Feel free to yell at me if I miss some comments. Sometimes I forget to take a look at the comment section because there's a lot going on this end, doing it by myself. And also, as a legal document preparer / legal document assistant in California, we are unable to give legal advice. So the help that I can give you today, if you are reaching out to us live, is give me 1 second here, is about forms helping you guys with the forms. If you got stuck with your paperwork, if you are having trouble getting your judgment through, if you happen to get me on this live preview or video rather, feel free to ask your questions and I'll do my best to help you out for free. If you're watching this on the replay, I will go back in and put the timestamps in so you don't have to watch the entire segment. You can look at the timestamps and I will put in a description of what we're talking about at various points in the show. Okay, so let's get into some of the issues. And during the week, we have people call. A lot of them become clients. Some of them don't. But they're looking for help with their divorce. They've started it on their own. They've run into trouble, and we're talking about different various courts as we do work with all courts in California. So these are with different courts. The process with divorce is the same throughout California. Most of the forms are identical. The process is identical. However, with some of the courts, they can be a little bit more challenging. They have certain clerks or judges that want things done a certain way with their particular courtroom. And I'll be addressing some of those today as well. So let's get into some of the topics. Again, if you have any questions as you're watching this, feel free to ask away. And even on the replay, if you're watching this and you have questions, enter them into the chat, or if you're on YouTube, and make a comment, and I will make sure to answer that question for you. Okay, so let me just take a look at what we have here. So we're talking about filing default judgments when in agreement because you think a response is necessary. Okay, so one of the questions that came in this week, and someone who became a client of ours, is in filing a default judgment. So a default means the respondent did not file a response. Now, there's two types of defaults. There's default with agreement and default without an agreement. So in this particular case, they tried to submit a default without an agreement to court, even though they agreed, because they thought that a response had to be filed in order to submit a settlement agreement to court and thus have to pay the $435 fee. That is not the case. With a default with written agreement, you can submit a full marital settlement agreement to court without the respondent having to pay a filing fee. So they were trying to avoid the filing fee and therefore filing a default without an agreement. And those are the toughest cases to get through the court. Default with written agreement or without agreement is the toughest case to get through the court because everything defaults back to the laws of the court versus you having an agreement. So they're very challenging. We don't even like to take them. And I talk about this all the time. So the fix for this person who became clients of ours was all we have to do is turn around and re-prepare their paperwork and submit the judgment as a default with a written agreement, and it'll go right through the court. So do not do defaults without an agreement unless it's a last resort, meaning your spouse will not cooperate or participate, and you have no other choice but going through the default route. Okay, next subject. So I had a call where the client says, and in my consultations with folks, one of the questions I always ask is, are you and your spouse cooperative? Are you and your spouse in agreement, etc.? So sometimes the answer is yes, we're cooperative, or yes, we're in agreement, but my spouse isn't going to participate and they aren't going to do anything. And that is going to fall back to what we just about being a true default case, a default without a written agreement. Again, the most difficult and challenging type of divorce cases to get through the court. The only time a true default case is simple to get through the court is if there's no assets, no debts, no children, and a marriage of less than 10 years, then you can get a default divorce through the court if you file the petition the right way, because there's a special way you have to do it to make sure that that goes through as a true default, no agreement type case. But where one spouse will not participate, but they're not fighting it, they might as well, I would tell clients, it's better for you to have your spouse fight you in the divorce and file a response and go to court and go to trial than trying to push through a default judgment. That's how tricky they are. So I would encourage your spouse to file a response so you can get into court, because you can't get a court date and bring your spouse in unless they've actually responded. Okay, taking a look at the next question that we had that came in. Okay, so this was in regards to how to remove your spouse from your home when going through a divorce. So there's different ways you can do this, and some take care of it entirely, and some take care of it just off the deed. So what's going on right now is people want to keep their house, let's say, but they don't want to refinance because they may have a 3 or 4% interest rate, and to refinance and cash out their spouse is going to put them into the 6 or 7% interest rate. So they're not wanting to do that. So they say, well, Tim, what other options do I have for taking my spouse off the house? Well, the only other thing you can do is to remove them from the deed. But the problem with that is they're still on the loan, number one, which is going to prevent them from going out and buying another property because it's going to show up on their credit report. But number two, unless you refinance, then you cannot. How are you going to buy out your spouse at all in the first place? So that becomes the issue. We do have some clients that for that reason are keeping their home together. So they're going through the divorce. In fact, we just finalized a case a few weeks ago that they did this. And the only reason they're keeping the house is because they want to let the property go up in value, hopefully, or interest rates come down to a point where they can either one, refinance it, or two, sell it at a better profit. We also had some clients, and this was interesting. They recently bought a house and they're still within that 2-year mark. So they have to live in the home for 2 years. Otherwise, you have capital gains tax. So even though they are filing for divorce, they are planning on selling the house in the future. I believe it's going to be about 1.5 years from now, because they want to wait until that capital gains tax will not apply to them having been in the house for 2 years. And that's fine. Keep in mind, when you're going through an amicable divorce, you guys get to make all these types of different decisions. No one else is going to make them for you. And that kind of leads me into one of my next subjects is people often ask, do we have to, what is the court? Here's how the question comes in. What will the court say about our agreement if we do not have equal division of our community property? The answer is nothing. The court does not get involved in the division of your assets and debts if you guys have a full written agreement on all terms. They're not going to look to see if it's equal or if the values are equal. They're not going to call you into court to discuss that. If you have a full settlement agreement on all issues, you can divide up your property however you want. You can keep all the assets, and your spouse can keep all the debts, and the court won't care. Okay, let's see what else we had come in. I have a bunch of notes and lots to talk about. And again, any questions that come up, feel free to ask in the chat, and I will see if I can get those answers out to you. Okay, so the next thing that came in. Okay, so a note says court giving wrong information to dismiss a divorce case simply because it is old. So we had a call come in from a client. When I say client, they are coming in as consultations, and then they become clients. They were trying to do their own divorce, and they had a 15-year-old case. Might have been 18 years old, so a very old case. They went down to the Stanley Moss courthouse, and when a case is that old, it's going to be in archives. It's going to be. I used to work there at Stanley Moss. They have in the basement. They have all of the archived files, and depending on how old it is, it might even be just on microfiche versus actual copies of your case. I've had to pull the microfiche before, way back when I first started doing this. But anyways, if you have an older case that is open, you can continue on and finalize that case, even though it's beyond the 5 years. We had this particular client, they had went to court, said, talk to the clerk, and they said, yes, your case is still open, but we recommend that you dismiss that case and start a new case. That is absolutely the wrong information. You can finalize an open case. Now, what will happen sometimes is you will go to finalize your judgment. I've had this personal experience several times. An open case, 5, 10, 20, 30-year-old case, we've done them all. And we have submitted reactivated the case, submitted the judgment, and the court rejects the judgment saying, oops, you're beyond the 5-year maximum in finalizing your case, file the appropriate motion or dismiss the case. All that means in their fancy language is that there is a stipulation you can file that says both the petitioner and respondent can agree to both you and the petitioner and respondent agree in a stipulation to continue prosecuting the case beyond 5 years. You sign it, there's a $20 filing fee, and now you can submit your judgment. Had this person listened to the advice of the clerk and dismissed the case, they had to start all over, first of all, but then pay another court fee to the court to start a brand new case. So definitely bad information, wrong information, and we were able to wrap up their case on the old case by filing a stipulation to prosecute beyond the 5 years. All right, let's see what is next here. All right. So we had already talked about the how to divide your community property. So we're not going to go over that again. Okay, so we have a client that wanted to get their divorce completed as fast as possible. So I'm going to give you a procedural tactic. If you want to get your divorce approved by the court as fast as you can, this is what you do. File the petition, get a case number. Right behind that, file the response. Right behind that, file your judgment. How does that work? So in a normal divorce case, now we're talking amicable divorce cases where I'm handling your case, I'm filing your paperwork, and you don't have separate attorneys. That's obviously not going to be the case, not going to be a fast divorce. But what we do is, because of the normal way of doing things, there's that whole waiting period once someone has been served. So let's say we filed a petition, serve the other party, and we do that by notice of acknowledgement, by the way. We don't do that by personal service, but that's what starts the clock on the 30 days if it's personally served, or 40 days if done by notice of acknowledgement, a receipt of acknowledgement, sorry. So when that happens, you cannot submit the settlement agreement and all your final judgment paperwork until that amount of time has passed. Then the clock is still ticking on the 6 months, and it's still going to be 6 months in either case. But if you want to get your divorce decree approved by the court fast, this is how you do it. We would file, and this is what we're doing this week. File the petition, got a case number issued. You don't need to file a response, or you don't need to have it served, because the response takes the place of the proof of service. So day one, file a petition, get a case number. And that same day, if it's electronically filed like through Los Angeles County, we can file the response right behind it. And then the very next day, if the parties got us their agreement and we finalized their judgment and they got notarized and all that good stuff, we can literally submit that the very next day, and the court will review it and approve it. And you will be done with the court. It'll be approved. I should say pre-approved, because it's still going to be 6 months before you're actually divorced, but you'll have your court order signed by the judge, completely done working with us, completely done dealing with the court. The only downside to that is, of course, you would have to pay another $435 fee to the court to file the response. I think that's one thing a lot of people are unaware of. When you file the response, it triggers another $435 fee. But if speed of divorce process is what you're looking for, that's how you would want to do it. And again, that's what we did this week, and that case is finalized. All right, so we're going to see what we have next here. Okay, so another case that came in is in regards to the initial summons and petition. And this is someone I was just working with today. So how you file summons and petition will dictate if your judgment can be approved. And one of the issues that keeps coming up is, and not a lot, but enough to have to start over and amend your petition. It's one of the worst things you can do that will have to amend your summons and petition. There's some mistakes you can make that will not make you have to amend your summons and petition, but this one is. Here it is. If you do not list the names on the summons and petition exactly the same, your divorce judgment will be rejected, and they're going to tell you have to amend your petition. So how does this happen? In this particular case, they simply just didn't put the person's name, the respondent's name, on the summons at all. So obviously it doesn't match because there's no name there. But what normally happens is on the petition, they'll put uh, Tim Blankenship, and then on the summons they'll put Tim S. Blankenship or some other variation of the name. The names don't match, the judgment gets rejected. So that's what happened in this case. So we do have to start over. Of course, that was only one reason the judgment got rejected. There's multiple reasons. Usually that's the case. So when that happens, you do have to amend your petition, summons and petition to correct that. And then, yes, it has to be reserved. It doesn't start the entire 6-month clock all over, but it does reset the clock on when you can resubmit the judgment based on the service date. Okay, next thing we have is, so here was the question that came in. It says, me and my separate husband are both in agreement for divorce. We have printed online divorce forms once, and I tried to file. The court clerk said paperwork is missing, and I don't know what I'm doing wrong. So what I told this client was, you just be glad that the clerk actually said the paperwork's not wrong, is not right. Usually they won't do that. How do these petitions get filed all the time that are incorrect with mistakes? Because the clerk's job is not to review them. In fact, they're told by their managers, do not give legal advice. Do not tell them how to fill out the form. Even if you notice it wrong, just file it, take their money, and they'll have to figure it out later. This clerk at least said, hey, your paperwork is so wrong. It must have been really bad. So bad that they said, we can't accept your initial petition. There's so many things missing. I told her that's a good thing because it just would have messed you up down the road. Judgment would have been rejected. And like half the cases we take, we have to amend the summons and petition and start over. Keep in mind, you do get one free amended summons and petition without having to go to court. So, and I say this because we've had people start their own divorce, make a mistake, have to amend it, and then make a different mistake. And now court will not allow you to make a second amended summons and petition without going to court because they're thinking there's something wrong. You guys really need help. So don't make those mistakes either. Okay. Issues that we personally, are and am having with the different courts, specifically, well, not specifically in LA County, but definitely in LA County, we're seeing some differences of how the courts are processing paperwork. And then certainly because we work with all the courts in California, we're certainly seeing differences in processing requirements and timelines and issues with the various courts throughout California. So most recently, we have been doing this 10 plus years. And most recently, we've had the Chatsworth court start to ask for filing fees that they normally didn't ask for in the past. So I'll give you an example. And I'm really getting into the weeds and the details here, but this will probably help someone out there. If you file for divorce and you file the petition, you pay the $435 fee. We purposely do not have the respondent file a response because it triggers that second filing fee, like I mentioned. We process it as a default with written agreement. Now, what happens when you want to make a change and file a stipulation to your divorce, meaning you want to modify something a year later or something like that? Well, that's not a problem. We file because the petitioner paid their filing fee, we file the stipulation in the petitioner's name, and there's a $20 filing fee for stipulations. What recently happened with Chatsworth this week is we filed a stipulation in this exact same situation, and the court saying because the respondent signed the stipulation, they want to collect that other $435 fee because they didn't pay their first appearance fee because they didn't file a response in the divorce. I argued this to the end of the earth with them for a week. I spoke with the supervisor in the courtroom. I spoke with the supervisor in the clerk's department, and they even took it to their manager. And they said that this has always been the case. And I say, how is that possible that now you want a $435 fee for a stipulation when for 10 years it's been $20? They couldn't give me an answer how that happened. So it'll be interesting. I may just start filing all my cases in Central. I'll tell you why. In LA County, at least, you have the option, regardless of where you live, to file in the downtown Stanley Moss courthouse. I will choose Stanley Moss downtown for a variety of reasons. One of them being if you are in a court that is problematic that we've seen over the years, like the clerks give us trouble, they're slow in processing, I will file it downtown. For instance, I no longer file in the Lancaster court. I will, if you live in the Antelope Valley area, I'm going to file your case downtown because they have their process wired, whereas Lancaster does not. They always have some weird loophole pulled lost my signal here a bit, but for certain courts, again, Antelope Valley, I'm gonna try to remember which ones we do this for. Antelope Valley, then insurance, any of those other branch courts, we will file in downtown Stanley Moss Courthouse. If you live in the Chatsworth Courthouse, I was filing your case in Chatsworth, but because of what we have going on with these weird court fee requests lately, I think I'm just going to have every single client that's in LA County file it downtown. It doesn't matter if I file your case downtown and you're nowhere near the court because you're never going to go to court. We handle all the paperwork. We take your paperwork down. We file it all electronically. You're never going to have to make an appearance. So it makes no difference if you're our client of where we file it, except for if it's one of these other courts and they give us problems, it's going to be a delay in actually finalizing your divorce. All right, so let's take a look at the next question that came in. Oh, just continuing on with courts making, or having different processes. We had a very strange case, only in that the way the court was asking for us to prepare the judgment. So again, half our clients come to us where they have started their divorce and then got to the judgment phase or somewhere prior to judgment, and the judgment gets rejected. So in this particular case, this was in the Fresno County Courthouse, and they wanted us. So what we normally do is we'll use the actual court forms. So if you're doing your judgment, the courts have the forms for you. So you have the FL 180, the judgment face sheet, you have the property order, the spousal order, and we like to use those because they have all the language already built in, and you're basically just filling out the forms and not having to add any special language. Well, this Fresno court clerk wanted us to draft a full marital settlement agreement, like the legalese, on official pleading paper. And their rationale was because when the petitioner filed their petition on their own, they said in the actual petition, like where the property disclosure part is, they said parties intend to complete a marital settlement agreement. Here's where the issue: that a marital settlement agreement does not have to be a written narrative like that. The forms, the combination of the property order, the spouse support order, the custody order, the child support, that totality of forms makes up the actual marital settlement agreement. It's just a different format, the forms versus a narrative. I explained that to the court. They don't like my answer. Of course, the court's always going to rule. They're the boss. So what did I have to do? I had to take the language from each of the forms and put it into a written narrative for them. Took several hours, not something we normally do, but that's what this particular court requested. And that's what we had to do. And we've never gone back to our clients to say, hey, wow, this really took us a lot longer than we thought to handle. And it did. It took us probably 6 extra hours to get this judgment drafted in the way the court wanted. But we did that for them. Don't ask for any extra money. Never have, never will. And that finally got approved by the court. So if you're just joining us and you have questions about the divorce process, feel free to plug them in, and I'll try and check the comments box and get to answering your questions. But what we're talking about is just issues we've had with people who have retained us this week and all the different things that they have come up with. Because if they're having these problems, you will have these problems, and we're having, obviously repeated problems. There's a lot of commonality with the issues people have getting their paperwork and their divorce approved through the court. So let me see what the next thing that came out. Okay, restoring your former maiden name. So this is just a bit of advice and advice I give to everyone that we work with. Whether or not you want to restore your maiden name, you should probably ask for it either in the petition and in the judgment. Just because you ask for your name to be restored, your maiden name to be restored, and you have a court order from the court that says you can do that, it doesn't mean you have to go out and do it now. Or I say it's good to do now is because if you want to change your name in 10, 15, 20 years, you have to file a additional name change paperwork with the court, and that could cost you an additional filing fee in doing so. So even if you don't want to restore your maiden name, or maybe you think you never will because maybe you have minor children or you've been married 30 years and you don't want to change it, you can always, if you think there's a 1% chance you may want to change it at some point, do it in the actual divorce case. Doesn't mean you have to do it. Okay, we talked about the summons and petition names must match and why that's important and how that will reject your judgment. Okay, here's my next bit. My next big pet peeve is these property declarations. When you file for divorce, you're talking about filing the petition, the FL 150, I'm sorry, the FL 100. There's a separate property section and a community property section. And it says, do you want to list your property in this little 2-inch box, or do you want to attach these 160 property declarations? So what do people do? They attach the property declarations. Here's why this is going to cause you a problem and why it is causing people problems with your judgment. Every time we get a client that hires us because their judgment's being rejected because of how their petition was filed, it's not every time, a lot of time, it's because of they attach these property declarations. So what happens is the property declarations are very specific. You have to list what the item is: a house, a car, a credit card, vehicle, whatever the case might be, when you purchased it, what the balance is, what it's worth, and what the equity division should be, and who you're assigning that to. Lots of issues come up with this. One, you're putting community property on the separate property form, or you're putting separate property on the community property form, or you're listing the property on there and you're not putting all the information, like the specifics. If it's a credit card, you need the last 4 digits of account, loans, bank accounts, etc., pensions. You need the account numbers. If it's a vehicle, year, make, model, license plate. So you're not doing that. You don't know to do that. And then when you go to submit your judgment, let's say it's been 3 months, 6 months, or a year. We just talked to someone who their case is 10 years old. Obviously, that property no longer exists in many cases, but you still have to dispose of it because you've told the court, here's our community property, here's our separate property. So they'll try and turn in their judgment, and they will not address the assets and debts on the property declarations that were attached to the petition, and their judgment will be rejected. And they'll say, Tim, can you help me? Yes. What do you have to do? We have to address what was in those property declarations, even if they're 10 years old and even if they no longer exist. So what we'll normally say is, XYZ asset listed on the property declaration no longer exists. You have to address it one way or another. You can't just leave it out. And then sometimes you can't, the courts, depending on the clerk, they won't allow you to add any additional assets or debts, especially if it's a default without an agreement. You definitely can't add any additional assets and debts because you did not list it on the petition. So if you do that, that will also cause your judgment to be rejected. So my advice, and this is not legal advice, this is procedural advice, never attach the property declarations to your petition. We write something to the effect of parties intend to reach a full agreement on all issues. You don't need to put assets and debts listed in there at all. But if you do, you have to address it in the judgment. The only time you should ever fill out the 160s, in my opinion, is when you know it's going to be a default without an agreement, and you doing so as a last resort, because again, they are the most challenging type of cases to get through the court. But that's when you actually have to attach the 160s, the property declarations, is when there is, no agreement and nothing's going to be signed by your spouse, nothing's going to be notarized, and there's no cooperation. That's when you will have to attach those. All right. So next thing we're talking about, okay, I've harped on that quite a bit. The last thing I want to talk to you about, unless I have something else that comes to mind or someone asks a question, is taking your case to trial. So we only handle 100% amicable, cooperative divorce cases where the parties have a full agreement or will have a full agreement and are not intending to go to court or fight over anything. That's how we do it. All courts throughout California, we can assist you in doing that. Once in a while, and is why I ask in our consultations, are you and your spouse in agreement? And because if you're not, we are going to be just as challenged as getting your case through the court, because we can prepare your petition, we can set it up to be served, but as soon as you guys don't have an agreement, we are done. We can't represent you. We don't go to court for you. I can file paperwork to get you into court, but that is not what we specialize in. So I'd prefer just not to take your money and work with you from the get-go. I'd say spend that money on an attorney if you know right out the gate you're not going to be in agreement. And that's usually what my recommendation is. But we've had some clients that don't want to pay the attorney's fees or don't have the ability to pay the attorney's fees. So I'm going to tell you how to handle your divorce if you're not in agreement and you don't want to use an attorney. Here's what you do. File your petition, get your spouse served. If you're the respondent, file your response, because you can't go to trial unless both parties have appeared in the case. So file your petition, file your response. Now you have both appeared in the case, And then every county has some type of trial setting request. It might be called by a different name, but essentially it's you saying, we have, I think sometimes they call it an at issue memorandum in different counties, but for LA County, it's called a trial setting request. Doesn't mean you're asking for a trial, it just says you're asking for a setting. So, what does that mean? What happens is you file this trial setting, you will get a court date in maybe 45, 60 days, depending on how busy they are. And I'm talking specifically about LA County now. And you'll appear at this hearing, and the judge is going to say, okay, what's going on? Well, okay, I see you've done the petition. I see the response has been filed. Have you done your financial disclosures? Yes or no? And the judge is going to give you some direction based on your answers and based on what it is you disagree on what they want you to do. So let's say you guys are completely on in different fields as far as an agreement related to, I don't know, custody. They would probably say to go see, go set a mediation appointment, do the parenting class and have a mediation appointment and see if that can be addressed there. So they will give you direction. Doesn't mean you're automatically going to trial. It just means you're saying, hey, judge, we are not in agreement. What do we do? Judge is going to say, what are your issues? Here's our issues. The custody, go to mediation. Property division, maybe try mediation. Different, like Orange County has really good in-house mediation. LA County, they're trying to do anything these days to prevent you from having to go to an actual trial. To the court, trial is the last resort. It's not, hey, I'm requesting a trial. Sure, here's your trial date. No, there's so many steps before you actually will ever see a judge and have a trial. And this is what that looks like. Trial setting request, as I mentioned, go to your trial setting, tell the judge what the issues are. They'll probably try mediation, try different things. That doesn't work. They're going to say, okay, come back for another trial setting hearing. Okay, have you, what progress has there been? Well, we didn't come to an agreement in mediation. Okay, next step. Have you done your preliminary declaration of disclosures? No. Okay, do your disclosures and come back in 30 days or whatever timeline. You come back. Okay, have you guys reached an agreement? No. Okay, I see you guys have done your preliminary declaration of disclosures and there's no agreement. No. Okay, now we're going to do some pre-trial work, meaning do your discovery. Ask what you're going to ask. There's different discovery methods. This is not stuff we handle. There are other people that do what I do. They're happy to do that for you, but we don't handle any type of contested cases. But yeah, you can you do your discovery. You would file paperwork asking for specific documents. You will eventually get a trial date, but it's not going to be right off the bat. They're going to make sure that the court has put you through every process to reach an agreement prior to trial. So definitely recommend you guys work on agreement. We have an interesting, just kind of a side note. We have a case right now where we worked with the clients maybe a year ago. They reconciled, got together, and dismissed the case. And now, I guess about a year later, they are refiling. So, again, just making sure you guys are in agreement. Yes. Okay. So let's get the process started again. When you just dismiss your case entirely, you have to start over with a brand new case, pay the fees again. And I usually try and dissuade clients who are thinking of reconciling to let them know you can just let the case sit there for a couple of years, leave it open in case you guys decide to, finalize the divorce. You don't have to pay the fees again. Usually I am not listened to. So, and I get it. If you want to have a, truly try and reconcile, you probably don't want to have an open divorce case kind of lingering over you. So I kind of get it. So anyway, started a new case, got the case filed, and then he says, hey, Tim, my wife filed for divorce on the same day. I said, well, it doesn't happen very often, but it does happen. And here, simple fix. So it turned out, so we filed the case in Central Stanley Mosque around 11 o'clock. And it turned out and we do everything electronically. So we submit it, and usually in 15, 20 minutes, we have a case filed. She happened to do it either the same day or next day. So we had the lead case because the case was filed prior. So I asked them to upload a copy of their petition, because now we have two petitions for divorce, and those cases now have to be combined. So that's easily done. We file a stipulation to consolidate the cases. Generally, what will happen is the first case that's filed, we will consolidate the second petition, the later filed petition, into the first filed case. You guys sign it. There's a $20 filing fee for the stipulation, and it basically tells the court, okay, there's two petitions. These are now joined together, and the second filed petition will be treated as the response. Because if you look at the petition and you look at the response form, talking about the FL 100 and FL 100, they're basically the exact same thing. The respondent requests. So we would just combine the cases. I draft the stipulation and the portal client case to communicate, have three-way communication so everyone's on the same page throughout the process. And the wife was not signing it. So I'm emailing, following up saying, hey, just need to file this so we can combine the cases. And we're not getting any response. And the funny thing is I can see that she's logging in, but not taking any action. Then I guess I'm kind of telling a story here, not really relative to helping you with anything, but next thing you know, the husband says, hey, Tim, the sheriff is at my door trying to serve me. What should I do? I said, well, it's unnecessary because we're combining the cases. So no service is required. Just accept it. It's no big deal to change anything. So he does. So now I'm thinking, why, if all this spouse had to do is sign the stipulation to consolidate the cases, and if they're not in agreement, which is obviously the case, this person's obviously playing games, which we don't, that's why I don't handle trial cases or people that are not amicable or cooperative, because I have no tolerance or patience for people that are playing games. So I called her out and said, hey, I see you logging in, you're not signing it. Now you're trying to have him personally served by the sheriff's department. You're obviously playing games. So, we're done. So I told now our client said, hey, she's obviously playing games. This would be so simple if she'd sign the consolidation form. And then there's the thing. She's going through all this probably to try and upset him, and play games like I mentioned. If they want to fight it out, consolidate the cases. No one has to be served. I'm sure she took some joy in having him served. People do that to be mean, but consolidate the cases, then set your case for trial doing this trial setting request form. That's all that need to happen. And they can go have their fun in court and fight it out there. But I don't think we'll be able to end up obviously helping them unless she comes back around to reach an agreement, because at the end of the day, I personally feel if you can be amicable, with you and your spouse and set a motion aside, you will reach a better agreement than some judge who doesn't know you, doesn't care about you, and in 10 minutes of trial is going to make a decision that will affect your lives forever. That's just my honest opinion. So I don't see any comments that have come in. We've got about 38 minutes or so. So I think we will sign off. Again, I'm going to try and do these more and more, at least once a week, maybe a Thursday, 3 o'clock recap, going over these different topics. And again, if you're watching this on the replay, I will go back in to the video settings and I will put the timestamps, and I'll put in what we talked about at certain points in this. So you don't have to watch the whole thing. You can just search through the timestamps and look for something that may be of interest to you, the topic, etc. So this is Tim Blankenship, divorce661.com. I have some cool music for you that we're working with here, and we will see you next time. We are a full-service legal document preparation firm in California, specializing only in amicable divorce. So anywhere in California, we can assist you. Reach out to us, 661-281-0266, or go to divorce661.com. And you can schedule a free consultation, whether or not you become a client or not. I usually spend that time helping you the best I can to help you get your paperwork through the courts. And also, someone going through divorce, let them know that we do this free help. If you like our YouTube page, like us on YouTube. I'm still saying it wrong. Follow us on YouTube, whatever it is. So you get notified when we are doing these live. I try and schedule them out at least a day in advance, and you'll get notified so you can come in with your questions or just join us live and all that good stuff. So until next time, Tim Blankenship with Divorce661, and this was avoiding mistakes that these clients have made during the divorce process so you don't face the same problems. Talk to you soon.